A happy Thanksgiving to all of you out there. And if you just happen to be watching this after Thanksgiving, well, I hope you had a nice Thanksgiving. And thank you for tuning in even today. That may be after Thanksgiving. But if today is Thanksgiving and you're taking a little bit of time out of your day to tune into Brother Counsel Studios, taking some time away from catching up with your favorite family members who came in to visit, or maybe you came to visit them, or if you're taking some time away from the football that's going on today, I appreciate that. Thanks for tuning in. And it's probably a good welcome break anyway, right? Between you and me. But anyway, so thank you for that. And also, since today's Thanksgiving, let me give everybody out there a general thanks for all the support and encouragement that you've been giving me personally. I've been getting a lot of support through emails, from comments, people that have really been encouraging me and supporting me throughout this entire journey that I've been on so far with this YouTube channel. So I appreciate that. Hopefully, by supporting my channel, you will also be supporting all of the other channels and raising the bar for all of true crime analysis, all out there. So definitely very much appreciate all the support and encouragement that you have all been giving me. And if you haven't yet, please definitely continue to support, hit that subscribe button, hit the like button, so we can continue getting this message out and more people can really get to the understanding of what's really going on with these high profile cases. So we are going to talk today about the recent Karen Read hearing. And there's probably been a few videos that have been put out about it already, but I think it's a little complicated and convoluted, and I think it went over a lot of people's heads. So that's what we do on this channel. We try to break it down and make it understandable and simple for everybody out there to really understand what happened and what is generally going on with these different motions and different hearings that occur in these high-profile cases. So before we jump into the actual hearing that occurred and breaking it down, I do want to do some housekeeping matters, and that is what is in the future going to happen with the Karen Read case. And also, we have a Sarah Boone sentencing coming up. So number one, we have the next thing is December 2nd at 1:30 p.m. is going to be the Sarah Boone sentencing. So join Brother Counsel. We're going to be streaming that live. And as you know, I've been doing a lot of videos on Sarah Boone, breaking down a lot of the arguments and understanding the law of what's going on with Sarah Boone. So definitely join me December 2nd at 1:30 p.m. when I'm going to be live streaming the Sarah Boone sentencing. We'll have a good time. We'll talk about it, and definitely join us then. Also, we have December 12th at 9 a.m. and the Karen Read case. We have a Daubert hearing, and that Daubert hearing is challenging the defense's expert, Dr. Marie Russell. You may remember Dr. Marie Russell was the expert who flew in from LA. She's extensive experience in forensics as well as an ER physician, and she testified very clearly that the marks, abrasions, cuts on John O'Keefe's arm were due to an animal attack and not by being hit by a car. Now, she was not able to testify that it's not due to a car, but she was allowed to testify, at least in the first trial, that it is due to an animal attack. And that's it. So that was her opinion. And now the new prosecutor, Hank Brennan, is challenging her under Daubert. And that's simply just a way to challenge an expert's methodology, challenging the expert's expertise. And like I said in my previous video, I don't think he's going to get much or going to get really much anywhere with this expert. She's extremely qualified. She's written papers about it, and to challenge her exact methodology, how she came into her opinion, I don't really see it being successful. But nevertheless, he does have the right to challenge her under Daubert. And of course, anything can happen in that hearing, and maybe he'll score some points, maybe he'll learn some more information, and who knows. So we'll see what happens with that Daubert hearing, but that's going to happen December 12th at 9 a.m. And I do hope to also live stream that. So definitely join us for that. So we got December 2nd, 1:30 p.m. Sarah Boone. We've got December 12th, 9 a.m. the Daubert hearing. Now, also a very big question in this case is, when is the next trial for Karen Read going to happen? There was a motion that was filed to continue the trial and basically just adjourn the trial, push off the trial till April. The judge previously took it under advisement. She has still not ruled on that motion just yet. It's under advisement because she wants to see how things are progressing. If things are moving along, then maybe she doesn't have to move the trial, or maybe she can only move the trial a month, or maybe only 2 months. But it was a joint motion filed by the prosecution and the defense, both seeking to push off the trial a couple of months till April to just get all their ducks in a row and ready to knock out the second trial, maybe even faster than the first trial happened. So we'll see what happens with that. Right now, as far as we sit today, it is still under advisement, so we don't know. And right now, the trial date is the end of January. So that might be happening pretty soon. So we'll see what happens with that. Now let's jump into the motion hearing. So there's a few different motions that were being heard. Number one was the motion to admit a new attorney, Robert Lessie, for the defense. So now the defense has Alan Jackson, Elizabeth Little, David Yannetti, and now they want to add another attorney who is a very experienced attorney. And it was just interesting because usually these motions are just filed and they're automatically granted. It's pro hoc vice. If you have an attorney who's not licensed in that specific jurisdiction, if you're licensed, let's say just in Michigan and New Jersey, and the Karen Reed team would want brother counsel to join their team, well, they'd have to file this motion for pro hoc vice because I'm not actually admitted in Massachusetts. So you're allowed to admit an attorney just for limited purposes, just for one trial, two trials. There's a limit of exactly how many pro hoc vices you're allowed to apply for and motion a court for, but definitely this is probably just only one or two. That's going to be fine. So generally these are just granted, but nevertheless, the judge did ask what David Yannetti about this attorney. And what was very interesting is that David Yannetti said that he knows no better trial lawyer in the country. Okay, this is David Yannetti speaking. And remember, he's got Alan Jackson, who's his co-counsel already. Alan Jackson's no small fish, right? But he's saying that this guy, Robert Lessie, he knows no better trial attorney in the entire United States. Now, I will say, just to qualify his statement, I will say that I do not remember David Yannetti sitting on any of my trials. So I'm just letting you all know that he hasn't seen actually brother counsel in action. So, we don't know for sure about that. Jury's still out about that. But nevertheless, David Yannetti definitely feels very strongly about Robert Lessie's competence as a trial lawyer, and he wants him to join the team. So he's going to join the team, and now we'll see exactly the division of labor, who's going to be doing what. Opening, closing, is that still going to be with Alan Jackson? It's going to be this new attorney, Robert Lessie. Who knows? It's going to be interesting to see how that all plays out. So that was the first very simple motion that was taken care of. The next motion was for it was two parts to this motion, and that was a motion that the prosecution filed that they want to get William and Janet Reed's call logs. That's number one, their call logs for 30 days. And also they want to get, for a 24-hour period, a full phone extraction of Karen Reed's father. Okay. So there's two completely different requests. And call logs is just to see who the person called, and just to see if Karen Reed, essentially what they really want to see is to show that Karen Reed did not have the habit or pattern of calling her parents at 1:00 in the morning. And Hank Brennan, he argued, the special prosecutor, he argued that Karen Reed did call at 1:00 in the morning. And remember, this all happened at around 12:00 in the morning at 34 Fairview, 12:24, around that time. And then Karen Reed calls her father, which goes unanswered, at around 1:00 in the morning. So he wants to show that this is very strange behavior on behalf of Karen Reed, and therefore a reasonable inference would be that she knows that she just did something, and that's why she's calling her parents for help, support, advice, emotional support, whatever it is. But she's calling because she knows that she just did something terrible. So that could be part of that could be a reasonable inference, which is why they want to just show, look for the past 30 days, how many times did Karen Reed call her father at 1:00 in the morning? So that's all they want to show with getting these call logs. So all you really need is the call log. That's all you really need. You don't need anything more, just to show, look, these phone calls never happened. They never happened at 1:00 in the morning. And he did actually leave open. He wanted to say that, well, if the defense wants to maybe show that, no, this is a pattern of Karen Reed, well, then maybe they can show call logs of 2 months or 3 months or 4 months or even a year to show that, look, Karen Reed did call her father or mother at 1:00 in the morning occasionally. So maybe this is just one of those nights. Now, another reasonable inference, by the way, I mean, I'm just thinking about this, but just another reasonable inference why Karen Reed would be calling so strange at 1:00 in the morning that night is not necessarily because she actually hit John O'Keefe, but because John O'Keefe's not coming out and she's calling him and she's texting him and he's not responding. So that could also be a reasonable inference that she's like, hey, what should I do? My long-term boyfriend, and now I have to go watch his two adopted kids, his niece and his nephew. And what should I do about this? Should I call the cops? Should I not? That could be also a reasonable inference. But you definitely, Hank Brennan can argue the other way that, well, reasonable inference is that she actually hit him. So nevertheless, this is what he's seeking, a 30-day call log, just a call log of Karen Reed's father and mother. Now, also, what he's seeking is it seems like a full phone extraction for just 24 hours for Karen Reed's father. The 24-hour span of when after this, January 29th, January 30th, around that time, get the 24-hour full extraction to see what was Karen Reed's father texting at that time. Who was he calling at that time? Well, Google searches was he doing at that time? So if Karen Reed actually told her father what really happened, according to the prosecution, that she really hit him, and she admitted that to him, and then he searched something about killing a boyfriend, or who knows what. But during those 24 hours, so therefore he also feels that Hank Brennan, the special prosecutor, feels that that's also relevant and admissible information that he should be able to get. And remember, in the first trial, Karen Reed's father was not called to the stand. And the suggestion, at least during this hearing, was that he may be called to the stand in the second trial. And just something that I'm sure maybe people were noticing while they're watching this is that Hank Brennan is definitely a very good attorney. You can definitely tell that. Some people may want to say that he's much better than Adam Lally. Nevertheless, you definitely see that he's extremely thorough. He's very smart, and he's well-spoken. He argues well. Definitely a very good lawyer. So that's something that we noticed right away, and he's definitely doing a lot of digging, and he's going to build a lot better of a case, it seems like, the second time. Now, whether that's actually going to be enough or not, we'll see. We have yet to see that. But he's definitely, I think this is going to be a little bit of a different case the second time than it was the first time. So those are the two things he was asking the judge. Now, something was interesting in the response, right? So Elizabeth Little got up to respond to this, and she said that actually there's absolutely no call log, seems, that Karen Reed called her father at 1 o'clock in the morning, which was confusing to me when I heard that, because we know that there was testimony in the first case by Trooper Garino, and it wasn't just him talking from his memory. He was shown a call log. Now, we didn't see the call log, but he was shown a call log which purports to show phone calls from Karen Reed to her parents that night, 1 o'clock in the morning, 4 o'clock in the morning, 3 unanswered calls. I think it was 3 unanswered calls. So when I heard Elizabeth Little say there's only one phone call that was made that morning or that night, and it was at 6 o'clock in the morning, or around that time, 6:27. So sometime, definitely not 1 o'clock in the morning or 4 o'clock in the morning. And there's only one phone call that was made. That just made me curious about, do they have different records? Are they arguing about different records? Is the defense position that those records are wrong? What's going on with that? So I was just a little confused with how strong of a position Elizabeth Little was taking, that there was only one phone call that was made. And she said very clearly that was made, not just that was answered. So I'm not exactly sure about what happened there. And they were talking a little bit, arguing about what actually Karen Reed's father meant when he said in a certain interview that his first recollection of what Karen Reed told him was that she does remember hitting something in response to a question about whether Karen Reed hit John O'Keefe. And the argument there by the Elizabeth Little is just, even though this is not really necessary for the motion, but the suggestion there was that no, he meant that Karen was talking about hitting the Chevy Traverse, when she backed out into, when she was backing out to look for John O'Keefe. Remember, we all remember that video where the car was nudged a little bit, and she did bang into something. So that's maybe what he meant, not that he meant that he hit John O'Keefe. And of course, the prosecution was arguing back that that's a little odd, that if it's in response to a question of, did Karen Reed say that she hit John O'Keefe? And then he says, yeah, she did say something about hitting something, and he really meant the car. Okay, but this is just argument that they can be making all day long. But the point is that therefore they want these records. They want these phone records. They want the call logs, and they want, exactly the full extraction of the 24 hours of Karen Reed's father's phone. But I think it was January 29th to January 30th. So we'll see what happens with that motion. I thought an interesting part of motion. I imagine, if I had to guess on that, I would say, I think the judge is definitely going to grant the 30-day call log. I think that's going to happen. I'm not exactly sure yet about the 24-hour, because that's very invasive. We'll see about that. Maybe Judge Cannoni will say, let's just get it out there. We'll have all the evidence. We'll discover it all. And then if they want to make more motions in limine about it, then maybe they could. We'll see what happens with that. So, but you took that under advisement. So that was the first interesting motion. The next motion was about getting the full unredacted interviews that Karen Reed gave with a number of different news organizations. So the first one was Gretchen Voss of Boston Magazine. And she has some text messages with Karen Reed, and she has hours of interview with Karen Reed. Some of them were aired, and some of them were not aired. And they wanted the completely unredacted version. And this is very interesting because what he argued, what Hank Brennan argued, was that, first of all, there was a 2-hour interview and they were only turned over 19 minutes of it. So he says, where's the other hour and 40 minutes of that interview? That's number one. Number two, there was a 4-hour interview that was given and only 3 hours and 19 minutes was aired, and that's all they got. Where's the other 40 minutes? They want the off the record, they want the unredacted, complete statement that Karen Reed was giving at the time. Now, what's interesting about this, and you have to really go all the way back to the first trial and the first motion hearings on this topic. And he did. Hank Brennan went back, and he seems like he's extremely thorough. He's really seems like he's doing a really good job and really digging into this trial, into all the discovery and getting all of his ducks in a row. And it's very, he's definitely a good lawyer, right? So he went back, he listened to this hearing, and in the initial hearing, it seems like Adam Lally didn't even ask for the attorney conversations that were happening with Karen Reed at the time. Now, what you will assume, what everybody assumes is, wait a second, that seems very reasonable. After all, why should Adam Lally be asking for the attorney's statements? Obviously, the attorney's statements are not admissible. And the attorney's statements or conversations with Karen Reed, that's attorney-client privilege. That's not discoverable, right? So it actually kind of makes sense that Adam Lally was not asking for that. Nevertheless, Hank Brennan said, no, that's actually not the way it works. And he's actually right about this. It doesn't work that every conversation that an attorney has with a client is automatically attorney-client privilege. It really depends who else is in the room. Protected attorney-client privilege is only conversations that happen directly with the client and nobody else there. There's no third party there. If there's a third party there, that breaks the attorney-client privilege. Okay, that's something very important that all lawyers most likely know. If there's a third party in that room at the time, then there's no attorney-client privilege there. So here you have a conversation that was happening between Karen Reed, the attorneys, and Gretchen Voss. Well, if Gretchen Voss was there, so then that means that there's no attorney-client privilege. If there's no attorney-client privilege, then guess what? All of those conversations are technically discoverable. And definitely everything that Karen Reed said is discoverable. And therefore, he's asking two things. First of all, he made a suggestion, which I think is a very interesting point. And I know some attorneys make a very big issue about this. And I've seen some times where attorneys get thrown off of a case because of something like this. And that is where the attorney can technically turn into a witness. An attorney obviously cannot be a witness in his own case that he's representing. So sometimes an attorney can be a witness. And you have to be very careful as an attorney that you don't turn into a witness. Now, here, if the attorney is in the same room with your client and the client's having the conversation with a third party, then you are technically a witness to that statement by the defendant. And that statement is not considered hearsay because it's the defendant's statement. So therefore, now you're a witness to the defendant's statement. So Hank Brennan actually made the suggestion that it could be that Alan Jackson and David Unetti are not even permitted to represent Karen Reed anymore because they turned into witnesses. And he can really push that issue. He really could, if he really wanted to be those type of attorneys, he could have really pushed this issue. Now, I don't know if he wouldn't have gotten anywhere because, again, they would not necessarily turn into witnesses. There's definitely a lot of case law you could argue back, but he didn't push this issue, but he didn't mention it to let the judge know that I can even turn these attorneys into witnesses, and therefore they would not be allowed to represent Karen Reed. Because again, once the attorney-client privilege is broken, once there is no attorney-client privilege there anymore, then the attorneys can technically be witnesses. And since this other reporter was there, so then that broke the attorney-client privilege, and they could have been considered witnesses. So he said, I'm not going to be asking for that. Now, there's also another question, which is going to be brought up again later, and that has to do with the reporter's privilege. Is there a reporter's privilege? Now, different jurisdictions deal with this differently. If you want to talk to a reporter and you want to talk candidly, do we give any sort of privilege that therefore those conversations are not discoverable either? Just like an attorney-client has a privilege, just like there's a spousal privilege, well, then maybe there's also a reporter, a journalist also should have some sort of privilege when they're talking with a subject that they're going to be giving an interview with. So it happens to be in Massachusetts, there's no reporter's privilege, or maybe it's very limited. not the same, not as broad as in other jurisdictions. So therefore, he's arguing there's no attorney-client privilege, there's no reporter's privilege, and therefore we are entitled to the entire unredacted communications that occurred during that interview. And he said, if you watch those interviews, it's actually very interesting. And he got everything transcribed, and he's got everything bait stamped and described. He's extremely organized. So we're going to be seeing a very different trial. Just trust me. But nevertheless, he said that if you look at some of those recordings, what happens is that there's a certain part that's recorded. Then all of a sudden there's an attorney conversation with Karen Reed. And then all of a sudden you notice that the story changes, or more details get added, or details get left out. And that seems that because the attorney is advising the client at that point what to say, what not to say. So that would be like if Alan Jackson or David Unetti was there, and then Karen Reed starts talking about something, and then David would say, hey, stop for a second. Let's go off the record. And then he would tell her, don't say that. That's not going to be good for you. Let's change it and say this. And then they go back on the record as the interview, and she changes the story. Well, those conversations, Hank Brennan argues, should be discoverable. What David Unetti told her, because if this reporter was there, then those conversations are not privileged anymore. And that obviously would be could be extremely damaging for Karen Reed. If the prosecution hears, the Commonwealth hears about what conversations she was having with her attorneys at the time that she was giving this interview, and how her story is changing or being modified for this interview, that could be extremely damaging for Karen Reed. And that is what this prosecutor is asking for. So just understand what exactly is going on, because these statements are admissible. It's a statement by the defendant, and they would be admissible. So this is a much more important issue than I think a lot of people are realizing. What exactly Hank Brennan is asking for, and how much it can change the way that this second case is going to be tried. So this actually was a motion that was this motion brought up before? I'm not exactly sure if this was a motion that was argued, but yeah, this actually wasn't a motion that was argued before, and the judge allowed there to be further reconsideration of this motion if they so desired. Now, also, something that was interesting about this is the fact that Karen Reed's defense team did not have any opposition to this. Now, for many reasons, that looks very good, because it shows for posturing, it shows we don't care. We don't care what statement you get from Karen Reed. We don't care about the unredacted portions either. You can have everything, because there's nothing that she said that was untrue, and there's nothing that she was trying to hide. So for posturing purposes, it's very good for Karen Reed's defense team to not take an opposition to this motion. This is actually opposed by the Gretchen Voss and the Boston Magazine's attorney. They were the one that were opposing this motion. And part of the reason was that she was very nervous, that he's very nervous, the attorney for Gretchen Voss and the Boston Magazine, that it's going to really affect her ability to be a journalist. Number one, you're turning her into a witness. If she's a witness, then the rule of sequestration applies, and therefore she's not even going to be allowed to cover this trial. She's going to be sequestered. So she's not even going to be able to try. You're hindering her ability to do her job. That's number one. Okay, now if a journalist happens to be a witness for something, well then okay, you just can't cover the trial. But that's number one. Number two is that you're kind of showing people that the integrity of journalism is going to be at stake, because here you have someone who's having a confidential conversation with a journalist, and now they have to say everything that happened in that conversation, even the things that were off the record. So it's really going to be a challenge to this freedom of the press and those type of protections. So that was part of the argument that the attorney for Gretchen Voss and the Boston Magazine made back. Also, he said that she's scared for her life. She's scared. This is a very contentious. This is very emotional. This case obviously has gone a little nuts. People have taken sides, and witnesses and journalists are scared for their life, and therefore she's scared that if all of her notes and all of the unredacted and conversations and off the record conversations come out, who knows what that's going to do for her safety. So that's another reason why he was opposing this motion. But in terms of the defense for Karen Reed, they took no position on this, which means that they're not opposing it, which shows, at least posturing, that They could care less. They don't mind if everything comes out. They let more information. The more information, the better, because that would just show that Karen Reed is not making up stories and that she's 100% saying the truth, and she never hit John O'Keefe. So posturing wise, it's very smart of them to not take a position. If there's something that she said is very damaging, well, then, that might come out and may change the case. All right. Now, and part of the prosecution response was that we're very sorry for Gretchen that she feels scared about herself. But guess what? A lot of the witnesses for the Commonwealth, they've been harassed also. In fact, there was someone who was charged with harassing witnesses. So, it goes both ways. Commonwealth also has witnesses that they wish were not involved, that were technically getting harassed or allegedly getting harassed. So, that's just how this case works. And it's sad. And of course, we don't want this to happen. And this is not how the justice system should work. But nevertheless, that's the reality of this specific trial. And therefore, if prosecution witnesses are getting harassed, well, then that's just what might happen to some of the defense witnesses. So that was part of the response there. Okay, then there was another motion. The next motion was with regards to some other interviews that was going on with other channels and other news outlets. And what happened here was very interesting. Okay, so just to understand what exactly happened, because again, I think this was an issue that went over a lot of people's heads. If you have a company and the company is registered to do business in New York, so that's where its principal place of business is. Now, sometimes that company will do business in other places. You can do that. You can have a New York-based company that does business in all different types of states and all different jurisdictions. And what will happen sometimes, if let's say you have an affiliate in a different state, well, they'll have something called a resident agent. Okay, a resident agent is just a place where you can receive mail on behalf of your company. So you have a company in New York, which is really the principal place of business, but you do some business also in Michigan. So you may have a place in Michigan where you want to get some mail if somebody wants to serve you some papers or any sort of mail. So you'll have something called a resident agent there in Michigan or Massachusetts in this case. So what does that really mean, that you have a resident agent there? What does that mean? Does that just mean that you can get some mail there? If it just means that you can get some mail there, then great. That's all that's going to happen in this. If there's more that's involved, so then that can really spell some problems. So here you have a subpoena for documents, and they want all of the interviews and everything that was done for the ABC show. So for anything that was done under ABC, they want all of the documents. Now, ABC is a company with its principal place of business in New York. Now, they have a resident agent in Massachusetts. So they served a subpoena on this resident agent. But here's where it gets very interesting. In New York, there is a reporter's privilege, and it's very, very difficult to get any sort of documents from journalists in New York. Okay, just so you should know. So maybe if any of you have these high-profile cases or need to do an interview, the best place to do it is go to New York. Okay, so that would be the best situation. But here, what happened was, so you have this parent company in New York, and then you have this situation that happened in Massachusetts, and you have Karen Reed giving an interview, and they want these documents, and they served a subpoena on the resident agent. So the question is, okay, so does that just mean that you served the subpoena, that it's considered good service? But where do you decide which jurisdiction do you have to prove that you're able to pierce this privilege? So if you're in New York, you have to go to New York court. Well, guess what's going to happen? Most likely you're not going to get anywhere, because the reporter's privilege in New York is very, very strong. The reporter's privilege in Massachusetts is not so strong. So therefore, Hank Brennan is asking a Massachusetts court, Judge Cannoni. She's saying, hey, look, we just served a subpoena. We want these records. And the response is, very nice, but you don't have jurisdiction, because if you want these records are being held in New York, and that's where the ABC's principal place of business is. So you're right that we have a place to receive mail in Massachusetts. You can receive mail. We have a resident agent there. You can serve legal papers here, but that doesn't mean that the New York company is subject to jurisdiction of Massachusetts. So that was the argument. Now, excuse me, Hank Brennan responded. He says, let me give you an example of what this is like. And obviously Hank Brennan wants Massachusetts to have jurisdiction over this request, over the subpoena, so that he can actually get the records, because they're not protected. There's no privilege in Massachusetts. So his argument was the following. Let's say you have a U-Haul truck, and a U-Haul truck is involved in an accident in Massachusetts, and you want to get some of the corporate documents that have to do with U-Haul. And U-Haul's principal place of business, let's say, is in New York. So you have the case in Massachusetts. That's where the accident happened. And as the attorney who's representing the plaintiff, you want to subpoena these documents from U-Haul, the corporate documents. Well, do you have to go to New York and petition a court there to get these documents, or do you just simply file with whatever court you filed this lawsuit in? And the answer is, of course, you can ask the court in which you are pursuing this action in Massachusetts. So therefore, he said it should be the same thing. Now, the response to this was that it's completely different, a civil case than a criminal case. And also there's a statute specifically which says when you want to subpoena an out-of-state witness, certain things have to happen. And one of the questions that Judge Cannoni asked was, well, does the same statute apply when it's talking about witnesses that are out of state and documents that are out of state? Because in this case, excuse me, but in this case, documents that are out of state is different than perhaps witnesses that are out of state. And this is what the attorney responded that no, the statute specifically, or the case law specifically, says that subpoenaing documents is the same thing as having a witness out of state. And since this is a criminal case, there's a specific statute which says what has to happen in order to get this witness to come from out of state. And the same thing would apply for documents that you want to get. And again, these documents are going to be the unredacted conversations and interviews that Karen Reed did with any ABC affiliate. So that's the argument here. And part of why this was kind of left on hold is that because this response was filed very late by the ABC legal team, and the Hank Brennan didn't really get a chance to look at some of the case law that they cited in support of ABC's position. So he was kind of arguing on the fly. So he's going to have to file another follow-up response to that, and we'll see where that goes. So we're going to see how this all ends up, but I thought it was a very interesting hearing. Hopefully it's all very clear now, these different issues. Most of these things were taken under advisement, so we have to still follow the docket and we'll monitor the docket and see when these decisions are actually made. So that's what exactly happened with the Karen Reed case. If it is still Thanksgiving when you're watching this, I hope you have a wonderful, great Thanksgiving. Enjoy the family, enjoy the football, enjoy the weekend, and thank you for tuning in today, and spending some time with Brother Counsel. Again, if it's after Thanksgiving, well, I still appreciate you tuning in. And definitely, if you haven't yet, please subscribe, like the video. That'll be a great way to show your thanks to Brother Counsel. And that will be it for now. We will see you later.